Well, ladies and gentlemen, good morning for the second time. By my clock, it's just gone 11 o'clock. And so as we have quite a bit to cover today, I'm going to introduce today's webinar. So welcome to this, which is the latest in Cornerstone series of lockdown webinars, and indeed the first of 2021. Today, as you'll see from the screen that we're sharing, you are logged on for Allocation Schemes, Lessons from the Court. My good friend and Cornerstone roommate, Andy Lane, and I are going to be covering topical issues in housing allocation, especially issues, as the title suggests, that have been argued and litigated in the courts in recent years. You will see a picture of the two of us. I can't believe Andy actually put these on the slides, but I'm obviously the one on the right and Andy's the one on the left, but it probably didn't take you a genius to work that out. Andy today is going to be taking a look at an overview of housing allocations by way of a brief introduction to the topic. And then he's going to be tackling, and I don't envy him this, the more vexed issues of reasonable preference under allocation schemes and discrimination. Before handing over to me, and I will be then looking in some detail at the public sector equality duty, at the effect of incorrect allocations and misrepresentations in the course of allocation, and at the remedies available to claimants should they be aggrieved by an allocation decision. Before I hand over to Andy, therefore, a couple of quick announcements. First of all, as I said, this is the first in the 2021 program of webinars, and that program will be released and published very soon. So keep your eyes peeled. I'm sure news of that will be forthcoming shortly. And the same as our newsletter, the housing newsletter, the first of which will be published, I'm told, next week. And full credit there to Andy and Tara for the work they've done in putting that together. If by now you've not already signed up for Cornerstone's regular updates on housing law, allocations, homelessness, etc., then please pop online to our website, and it's possible to sign up for those updates, whether it be newsletters or briefings, by simply registering online. One last thing, again, credit to Andy for the slides for today, the majority of the work of which Andy did, and I was a small contributant. So thank you very much to Andy for that. Without further ado, over to Andy, and I look forward to speaking to you again shortly after his stint when I'll be covering public sector equality duty. Andy, over to you.
Thank you very much, Dean. And we don't have long today, although we do have time at the end for some questions. But if we have a look at the next slide, it's a citation from Ahmed and Newham, which many of you, particularly those of you who are familiar with allocation schemes, will have read before. Those of you who have been involved in putting skeleton arguments in will have cited this, because everyone cites this. Because of course, what it basically says is that the court is not there to write allocation schemes. That is the job of the local authority, and the court will be reluctant to interfere. And as you can see at the end of that citation, Lord Neuberger, the former president of the Supreme Court, said it's only going to be in relatively rare and extreme circumstances that there'll be intervention. Of course, one of the issues is that there are problems with discrimination matters, and there are also problems with reasonable preference issues. And those are the two matters which have tended to come before the courts over the last 5 or so years. And indeed, if one puts into Westlaw, just by way of example, housing allocation and Part 6, one can see 54 cases come up. So whereas Lord Neuberger may have hoped that the challenges to local authorities are going to be fairly limited, I think the reality, and often with some justification, is very different, because these are not simple, straightforward matters. And it therefore means that one has to be very careful in terms of drawing up the scheme and its proper application. But if we then look at the agenda and what we're hoping to cover today, we are looking first of all at an overview, and it's got to be an overview because we're focusing here on some of the cases, but it's an overview of the allocation scheme's flexibility, powers and duties, I'm assuming that many of you, if not all of you, will have a fair grasp of that. We're looking at residency qualification discrimination, what I would say is one of the main issues that has arisen in the courts over the last 5 or so years. We're looking then at reasonable preference individuals. In other words, those categories of people who should be given reasonable preference, can they be excluded from the scheme? That's my bit done, and I'm passing over at that stage with Dean champing at the bit because I've undoubtedly overrun, saying it's his turn, and he will start on the public sector equality duty, our favourite subject, false information, remedies, and then there'll be a chance for discussion and questions. There is in fact a Q&A facility at the bottom of the screen, and when I'm not speaking, I'll be looking at that and trying to answer any that are straightforward. But of course, if there are other questions, we'll have an opportunity at the end of this session to look at those. So without further ado, assuming you're at the right session, let's have a look at some of the statutory requirements. Of course, we're talking here about local authority allocation schemes. There are no such statutory oversight provisions in respect of private registered providers of social housing, such as housing associations. They do, of course, play a part in allocation schemes for local authority because, of course, there is section 170, as you can see there, and they do have a duty to cooperate, I think the phrase is to such extent as is reasonable, to offer accommodation. And normally you would see that by way of nomination agreements between the local authority and the local housing associations, whether that's formal or informal. There would be those preferences. And of course, there may equally be individual cases where the housing association is called upon to assist as well. I have cited a case, despite saying this is about a statutory overview, which is Osman and Harrow of 2017. And this was effectively just to give an idea of the kind of issues that may arise. This was a 2017 case where the claimant was challenging a Band C award. And she had previously been on the scheme before it had been amended, and she'd been in Band A. And she claimed that the changes to the scheme meant that the scheme itself was in breach of Article 8 and involving, therefore, Article 14. In other words, it was discriminatory because it was unfair, and we don't need to know the facts of this in any great detail, but essentially it was unfair because it didn't really give proper weight and reasonable preference to those who would otherwise come within the reasonable preference categories in the private rented sector. And the council in that case took the view that they could alleviate overcrowding issues and such like, where those cases may come within the reasonable preference criteria, much quicker by placing people in the private rented sector. And that's not something they could do, of course, with transferees from their own stock or from housing association stock. And the court said that is fine. That is proportionate, and that was legitimate and justified to meet a legitimate objective. And it was perfectly reasonable to look at the scheme as a whole, both in terms of Part 6 and Part 7. And it's why, of course, you'll often see allocation schemes refer to the private rented sector offers that are available under Part 7 and homelessness provisions. They are part of a general overview as to how people in housing need can be assisted. And it would be perverse not, of course, to take a look at Part 7 when looking at housing need. Localism Act changes, well, what that did, of course, that brought a lot of people off the schemes. Those people who had thousands and thousands of people on the schemes. I could have gone on Redbridge's scheme, for example. I can't now because, of course, most schemes are using the powers given to them from 2012 to restrict who can go on there. And in particular, of course, one of the obvious qualifications is that you must be in housing need. So the Localism Act made significant changes, but of course has also given rise to some legal challenges as to whether the qualifications have gone too far or whether they haven't had sufficient exceptions. Eligibility, of course, is there. There are restrictions. Indeed, one of our pre-questions we had was an eligibility question, which I will address at the end of this session on the Q&A matter. Reasonable preference, in other words, despite the fact that the scheme is there to be set up by the local authority and to be set up at the behest of the local authority through whatever emphasis it wants to play, such as, for example, people working in the borough, people with a connection with the borough. There are certain groups of people that need to be given preference, which we'll see later on. But they, of course, include groups such as people who are homeless. And of course, allocation is by the scheme. There's no point having an allocation scheme if half of your properties are being allocated by management transfer. It's by the scheme. It should be transparent and it should be open and clear what is actually going on. So that's the statutory requirements. And then the guidance itself, when we look at the guidance, it is, of course, there to assist. And as with homelessness, it's there to be had regard to. And all I'm going to say for the purposes of this slide is that you'll need to be aware, of course, of the long-standing guidance, which is the first bullet point, which was introduced in 2012 and was updated at the end of last year, not exclusively, but in part because of Brexit and, of course, questions of eligibility. And if you have a look at part 3, you can see that. Providing social housing for local people is, of course, something that anyone who is putting in a qualification requirement into their scheme, whether as an entry requirement or indeed as a priority requirement, should read that. And of course, it encourages certain areas for local authorities to look at, such as connection with the local area, working and so on. Right to move and social housing allocations, and improving access for victims of domestic abuse. So they're all important guidance, which when you're setting up your scheme or when you're reviewing your scheme, you ought to be having a close look at. So if we then have a look at residency qualifications, because having seen that the Localism Act allowed local authorities by way of amendment to Part 6 of the Housing Act to introduce qualifications over and above eligibility, we can see that that is done through the Housing Act at section 160ZA. And we can also see that there are certain provisions which can be looked at in particular. And indeed, if you have a look at most authority schemes, the ones that I've seen, you would see a housing need qualification. Maybe it would be about financial resources. In other words, if, for example, you're on an income of more than 30,000 a year, or it depends whether you're in London or not, I suppose, but if you have certain, if you have another property, etc., of course, you're not going to get on the scheme. Behaviour is another common qualification. And if somebody's had, for example, an antisocial behaviour injunction or a possession order for antisocial behaviour grounds, that may restrict their access to the scheme. And most controversially, perhaps, in one sense, local connection. In other words, either one doesn't get on the scheme unless you've been in the area for a sufficient period of time, and it tends to be anything from 2 to 10 years, or indeed you get on the scheme, but you don't get a leg up, you don't get a prioritisation until you have been in that area, or indeed both. And you'll see there are provisions expanded upon by reason of the regulations. The Armed Forces regulations is obviously meant to stop any attempt to use local connection provisions to prevent those in the armed forces or those who've served in the armed forces from being kept out of allocation schemes. That's a very broad overview. You need to look at the regulations to be precise, but it's a broad attempt. That's what it's saying. We encourage you to use local connection as a qualification, but please don't do it. And in fact, you mustn't do it to stop people who have served in the forces or bereaved spouses, etc., from having access to the scheme. Similarly, with the right to move regulations, you'll see in terms of those, it effectively is trying to assist people who are moving in particular for work reasons. And again, you shouldn't be trying to impede the local economy by making it difficult for people to take up offers of employment, etc. And therefore one needs to have regard to that where, again, one's making up the scheme or when one is reviewing it. And we've already seen the guidance, but as I say, for residency purposes, there is, it probably doesn't look very good on Zoom, but there is the providing for social housing guidance there, which is very thin and very brief, but necessary to read before you make any decisions as to qualification. Now, within that, one has what we call local letting schemes. Now, local letting schemes are quite common, and certainly some of the allocation schemes I've reviewed, and I'm sure Dean's reviewed, have had the local allocation schemes. And I've given the example there of C in Islington as being one such scheme. And that scheme was talking about new build on a particular estate and prioritising those people in C in Islington who had been resident on that estate. And there was an argument, and a perfectly credible argument on the face of it, that if, for example, you were fleeing domestic violence, it was a bit unfair, of course, if you were effectively kept out from that estate, because of course you hadn't resided there before, you were elsewhere and you were fleeing domestic violence. And Mr. Justice Baker obviously gave very careful thought as to whether that was a breach of either Article 8 and 14 of the Convention rights, or indeed of the Equality Act, and it was the usual Equality Act provision of Section 19, indirect discrimination, or the PSED, which Dean will be dealing with. He effectively decided that, of course, there were consequences for the claimant in that case. Of course, in one sense, she was being treated unfairly because through no fault of her own, she was going to get less assistance than somebody who had resided on that estate when it comes to allocating those new properties. But of course, there was also the other side of it to decide, well, why was that in place? And in many areas, of course, the problem is there are too many people seeking too few properties. And in terms of trying to encourage people who are working in the area, families who are in the area and grown-up children, etc., it felt that there was a legitimate aim being pursued by the policy and that therefore it was a legitimate scheme and one that could be justified, even though it did discriminate against the claimant. She did, I should say, just by way of postscript, she did actually succeed. It's only fair to say, because there was a lack of criteria for direct offers. And that just makes the point that you've got to be very careful when making direct offers, that it's clear from the scheme, not from anything else, from the allocation scheme, as to why you would make a direct offer and when. So you have that kind of example, and therefore it is available. All I would say about local letting schemes is that the key is making sure that there is a good reason for it. Is there any particular reason why there's a particular preference being given to a particular area? And obviously not to go too far, particularly when looking at it in the context of your allocation across the whole borough. And one has to see it in that context, but they are available. Having mentioned direct offers, and having mentioned, of course, this was the basis upon which the claimant actually succeeded in C in Islington, very quickly on direct offers, it's suffice to say, yes, they are available. And I have seen, for example, schemes which talk about if you've been in temporary accommodation longer than average, you will get an offer of accommodation and things like that. All I would say is that you need to be proportionate about it. It can't dominate the scheme, and you must monitor the actual use of it. You should be monitoring these schemes every year, but you should certainly be looking at why are we doing this? Is it helpful? Is it meeting our objectives? And why? So in other words, if you're going to have people who are in temporary accommodation longer than average, there is perhaps a reason why it's only fair that they be offered a direct offer of accommodation. Whereas in other circumstances, you may say there's no particular reason why that group has been prioritised. So be very careful about direct offers. They are important, but they should be limited. Looking at the more difficult area of discrimination, as Dean mentioned at the start, you'll see from this slide, and indeed the slides to come, I haven't, well, I would say banged on about it too much by having several slides. And one of the reasons for that is that to some extent, in terms of what we're trying to get across today, the position is quite straightforward. Now, I've put at the bottom of this slide what is generally going to be the matters raised. It's normally going to be indirect discrimination. Of course, Dead and Hackney was a case of direct discrimination, particularly in respect of the allocation priorities of Agudis Housing Association, to which there were nomination rights by the local authority. That's a direct discrimination case. But generally speaking, it's going to be indirect discrimination, and that therefore there's going to be evidence that a group is in fact suffering because of the particular provision in the scheme, and that therefore it's unlawful because it can't be justified. I've put down Articles 8 and 14. My own view is that if I was pleading on behalf of a claimant, which obviously I don't act for claimants in general terms, I act for local authorities, but if I was to plead, I'd be cautious about doing an Article 8.14, to be honest with you, largely because it doesn't add anything to the case. You know, for the lawyer, it might be interesting to know what the former Master of the Rolls thought about it. When one looked at H and Ealing, one might look at even Z and Hackney and have a look at what the Supreme Court. But it's noticeable that judges at all levels, from admin court upwards, are basically not willing to come to a conclusion because you don't need to. You know, if you don't get home, to be quite frank, on indirect discrimination, it's difficult to know how you'd get home on discrimination under Article 14. All I would say is that the jury's out, and I rather suspect it's more likely, if it ever had to be decided, it would be decided that allocation schemes probably are within Article 8, although traditionally it was felt that they weren't because there's no right to a house. This is purely an allocation of a possible house, and that therefore it kept it outside Article 8. And as you know, you can't invoke Article 14 unless you invoke another article. But I think the way that the trend was going, looking at the Master of the Rolls in H and Ealing and looking at some of the comments in Z and Hackney, I suspect if it ever needed to be decided, it would be decided that way. But just very quickly to make mention of some of the discrimination issues. As I say, Z and Hackney was perhaps a case very much of its own. It was a very limited part of the stock. And I would stress this, that is quite an important aspect. It was a very limited part of the stock. And of course, it was one of the few cases, in fact, it was the only case, as far as I'm aware, that looked at positive action under Section 158 of the Equality Act. And therefore, it's very important to look at it in that respect, but it's going to be of very limited value. Of more interest in the concept of it only affecting a limited number is cases such as H and Ealing. Now, H and Ealing, I mean, our colleague Matt Hutchins was in that, as he was in Z and Agudas, of course. H and Ealing was a case where there was a challenge to the working household and the model tenants uplift, but they only affected a limited amount of properties. So I believe, from recollection, the working household was 15% of the properties and the model tenants uplift was 5% of the properties. And therefore, it wasn't affecting the whole scheme. And therefore, although it undoubtedly discriminated against women, against the elderly, against the disabled, and in the context of the model tenants, of course, non-council tenants, insofar as that was the status for the purposes of discrimination, it was held to be justified because there was a legitimate aim. And again, this was the Master of the Rolls in the lead judgment. There was a legitimate aim in introducing such a provision. It didn't overwhelm the scheme, it was proportionate, and it was justified. And we'll see on the next slide really what's being looked at in terms of justification. And this is the what I would call the well-known, but when you say that, it gets a bit sad, doesn't it? Because perhaps it's not so well known, but there has been some debate, it's fair to say, as to what the test is, because in most of these discrimination cases, the reality is there is discrimination. In other words, there is an unfairness being caused by the particular provision. And just to read out Section 19 of the Equality Act 2010, it says at subparagraph 2, for the purposes of subsection 1, a provision, criterion or practice, and clearly a provision of an allocation scheme falls within that, in relation to a relevant protected characteristic, and of course that can be disability, sex, sexuality, gender reassignment, religion, etc., is discriminatory if it applies or would apply to persons with whom B does not share the characteristic, so it's to everyone. It puts or would put persons with whom B shares a characteristic at a particular disadvantage. And certainly Kelvin Rutledge at Chambers and myself were involved in the Gulu and Hillingdon case. And of course, the complaint there was that Irish travellers and refugees are being put at a particular disadvantage when it comes to a residence requirement. You probably don't need me to explain why, But clearly, in particular, the higher the number of years you have for a residence requirement, the more likely that is. And Hillingdon's was a 10-year requirement. And therefore, they were put at a particular disadvantage. It wasn't direct discrimination because it wasn't aimed at them, but it actually had that effect. But it doesn't put A at that disadvantage. Now, of course, that doesn't mean that therefore that's overall unlawful and has to be struck down, because it could be decided that it is a proportionate response to the legitimate aim. And this is what Lord Reid, the present President of the Supreme Court, said about it. Numbers 1 and 2 are fairly straightforward, not normally disputed. There normally is a reason why you're doing it. And for example, when it comes to saying that you have a residence requirement, the government's own guidance suggests that that's an ideal position to have when it comes to qualification requirements. So there's often a good reason why one wants a requirement such as residence. By saying that therefore you don't get on the scheme unless you've had X amount of years residence in the borough, with certain exceptions, that's obviously connected. So that's rationally connected. So 1 and 2 don't normally have a problem. It's 3 and 4. And often they're taken together, because often it's said, for example, well, okay, you can have such a measure, it does make sense, but you can have exceptions. Or you can have it not at the qualification and entry onto the scheme, but as part of the uplift and prioritisation when it comes within the scheme, so long as it doesn't dominate. So there was a less intrusive way of rewarding and making sure that people weren't discriminated against, and that therefore it wouldn't be dealt with. What it's not, and it has been argued about this, and I think from recollection, I think maybe even in C. Islington it was argued, it's certainly not a manifestly without reasonable foundation test. And generally speaking, the Bank Mellet test, for example, was the one that was used in Gulu, it was the one that was used in H and Ealing. And is the appropriate test to use. And indeed, XC in Southwark was another one where it was found with favour as being an appropriate one to use. So with discrimination, what one has to look at, and of course, Dean will deal with the PSED in a couple of minutes. I stressed a couple of minutes, Dean. But what one's looking at, therefore, is, okay, we've got this provision. We recognise that there are certain people that are going to suffer more than most. We recognise that there's particular protected characteristics that are going to suffer more than most. Can we still justify it? And in XC and Southwark and in H and Ealing, you had cases where the decision was, well, look, it's fair enough if it doesn't dominate the scheme. There's no point, for example, having a working household prioritisation uplift if you include people who don't work. So to say, well, it's unfair on people who are disabled, unfair on single parents, and et cetera, well, it doesn't work. But equally, of course, if that dominates the scheme, if that effectively is a really big difference between getting housed and not, it may become discriminatory. So that's what I would say about discrimination. And the last few slides are really dealt with the question of reasonable preference. Because reasonable preference, as you can see on the slide in front of you, and often there's an overlap between the two arguments, effectively says that you ought to, in setting up the scheme, give reasonable preference, and you can see the provision at 166A3, A, B, C, D, and E there, so I'm not going to repeat them. It's not the same as success. It doesn't mean you're going to be accommodated, as we'll see in a minute. It is possible to give reasonable preference, even if that is never going to bear out in terms of an offer. And it is basically a decision for the authority. And you can see that indeed from the next slide, where another man in a wig has been shown. I don't think he can hear this, so that's okay. Lord Justice Dyson, as he was at the time, basically said in Lynn and Barnett, preference should not be confused with prospects of success. Prospects of success depend on many factors, of which the most material is the fact that the demand for accommodation greatly exceeds the supply, and makes the point that it's possible to be given reasonable preference and never be allocated accommodation. And of course, in homelessness cases, and they are two of the categories of reasonable preference, a lot of those persons would be accommodated under the PRSO scheme anyway, and therefore would come off the register, because of course they would be no longer in housing need, having got their 2-year PRSO accommodation. Coming down to the last two slides, however, there is a debate. And again, when one says that as a lawyer, one tends to think, oh no, who's debating it? And I sometimes think it's probably just myself, between myself, and I'm not sure who's winning. There is a debate as well. Does that mean that nobody can be excluded? So if, in other words, if I'm homeless, it doesn't matter what I've done, I can't be excluded. Whether I've lived in the area for a while or not, whether I've behaved or not, whether I've got housing need or not, although in homelessness situations that may be more obvious. And if we can just quickly go to the next slide, just to give you the problem that you might think with the argument. The next slide sets out in 4 cases why that may be the case. And if I start with Lord Justice Lewison, in the last citation at paragraph 6 of the judgment in Gulu, he said that all eligible persons included in the reasonable preference groups, that's all of them, must be treated as qualifying for inclusion in the allocation policy. Now, this is the key really, because when one looks at the previous 3 citations from Jakimovic, Alamy, and H.A. and Ealing, they talk very much about groups and subgroups. And that therefore, if you say that somebody, for example, to take the example of Jakimovic, somebody in temporary accommodation through Part 7 can't be in an allocation scheme, well, you're omitting a group of homeless persons, And going back to the previous slide, what I would say is that, and as the last bullet point makes clear, the real key is whether it's a class of reasonable preference groups who are excluded or whether it's just the individual. And I've always thought that that made sense, because those policies which have, for example, a qualification to do with antisocial behaviour, well, how can it be right that just because you happen to be homeless, you can ignore that? But even more the point, I was thinking this morning, if you look down at some of the requirements of 166A3, you actually have groups of people. For example, if I'm living in insanitary accommodation, I need to be given reasonable preference. But equally, if I have another property, I'm not in housing need. And is it seriously going to be said that just because I fall within a reasonable preference group, I can't be excluded from the scheme, even though I clearly have no housing need, because I could, if I really wanted to, move to another property I own? Well, that would be ridiculous. And of course, it seems to me that therefore the scheme must be very careful about how one treats reasonable preference, but one doesn't have to take the view that every single person who falls within that group has to be on the allocation scheme. You can't, in other words, omit groups, but you can omit individuals. And can I just say as a last remark, it's quite clear that if one read 166A further, one can see that it talks about, and I'll read it out at subparagraph 5, the scheme may contain provision for determining priorities in allocating housing accommodation to people within subsection 3, and the factors which the scheme may allow to be taken into account include the financial resources available to a person to meet his housing costs, any behaviour of a person, and any local connection. Now, 2 points really on that. One is that's not just about those in the reasonable preference categories and how you prioritise between them. There is established law to say that that is something that goes beyond that. And if one has a look at cases such as Alamy, one can see that. You can go beyond just the reasonable preference groups in deciding in your scheme that, for example, financial resources is a factor, or the behaviour of a person is a factor, or the local connection is a factor. And that can be across the scheme. And it therefore means that when you have a scheme, it doesn't necessarily have to be the case that reasonable preference categories are at the top and that everyone else is below them. It's going to be much more nuanced than that and much more mixed than that. And remember, you're also comparing with people who don't even get on the scheme when one talks about giving reasonable preference. And therefore, one shouldn't be too caught in the headlights in terms of saying, for example, I need to look through subsection 3 and make sure that all of those groups are right at the top. It's going to be a lot more nuanced than that. But the fundamental question is you must be able to justify it, and you must be able to have a sound basis as to what you're aiming for. You must state that in your allocation scheme and how you have met it by what you have done in the provisions you have set out. And as long as you can do that, doesn't mean you're not going to get challenged, but it does mean you've got a coherent way of going forward. And not too bad, Dean. I'm probably 2 or 3 minutes late, but I'll pass over to Dean and have a look at through some of your Q&As in the meantime.
No, that's pretty good timing, Andy. Thanks very much. Well, as indicated right at the outset, I'm going to be looking in some detail at 3 issues today. First of all, the public sector equality duty, which, as we will come on to see by looking at some of the case law, is a commonly misunderstood obligation. And then I'm going to take a look at the effect of incorrect allocations and misrepresentations in the course of the allocation process. And finally, and probably quite briefly, at remedies. Most of the time will be spent, in fact, on the public sector equality duty. And so because of that, it's probably worth reminding ourselves right at the outset, and looking at this particular slide, exactly what the provision requires. And so as we know, it is enacted by section 149 of the Equality Act 2010. And it enacts that a public authority must, in the exercise of its functions, have due regard to the need to eliminate discrimination, harassment, victimization, and any other conduct that is prohibited by or under this Act, advance equality of opportunity between persons who share a relevant protected characteristic, such as disability, and persons who do not share it, and foster good relations between persons who share a relevant protected characteristic and persons who do not share it. It will be instantly recognizable, I suspect, that section 149 enacts not an obligation with a view to securing any particular outcome, but essentially what I like to call a stop and think obligation. And so in the exercise of its functions, a public authority must, at all material stages, stop and consider the matters to which section 149 says it is to have regard, the need to eliminate discrimination, eliminate harassment, advance equality of opportunity, etc. It is a stop and think obligation. Well, what are the relevant functions for the purpose of section 149 in the context of allocations? Well, as I think was expressed at first instance in H and Ealing and not overturned on this point, the relevant functions in this context are the setting up of an allocation scheme and its subsequent maintenance and application. And as we will come on to see in a moment, that necessarily entails an ongoing obligation to review the functions that are being exercised and their compatibility or their consistency with the public sector equality duty. Well, having taken a brief look at the provision itself, let's see what we can learn from some of the case law on the subject, both from some time ago and indeed from recent times. Well, if you read just one case about the public sector equality duty, my recommendation would be to read that of Brown and the Secretary of State for Work and Pensions. And that is because it provides some very concise, in about 6 paragraphs, concise and helpful guidance as to what the duty entails and how a local authority goes about complying with it. And so very briefly, we have 1 to 6 on the slide. So first of all, the public authority decision maker must be aware of the duty to have due regard to the relevant matters. That you may think is trite, but given that the duty requires, if we take a quick look back at the previous slide, regard to be had to these specific matters, it is difficult to see how you might have regard to all of them without obviously knowing about them. And then secondly, and importantly, the duty must be fulfilled before and at the time when a particular policy is being considered. And so before, in this context, you enact, or rather you approve an allocation policy, you must fulfill the public sector equality duty and carry out the exercise that it prescribes. Thirdly, the duty must be exercised in substance, with rigor and with an open mind. And this is perhaps of all of the 6 guidance points, the most important, and possibly the point where many local authorities fall down. So as we will see in due course, it is not a duty in respect of which you can afford to take a light touch. You must exercise it in substance. You must exercise it with rigor, that is in some detail and with an open mind. So it's not really a question of simply ticking boxes. And although, as we've seen in the homelessness context, there is no requirement to make express reference to the obligation itself when you are undertaking the exercise, reference to it and to the criteria that you have applied as a local authority will obviously help to reduce the scope for argument. Under number 4, the duty is non-delegable, and that is in essence saying that, look, the buck stops with you as the public authority, that you must ensure that the obligation is complied with. Importantly, under 5, it is also a continuing obligation. We saw at 2 that it is a duty that must be fulfilled before and at the time when a particular policy is being considered. But it must also be considered at regular intervals, and in particular if there is any change of circumstance, for example, a substantial change to your allocation scheme. And then lastly, and we will look at this in more detail on the next slide, it is of course good practice for a decision maker to keep records demonstrating that they have properly considered the duty. And this is a common complaint of many lawyers receiving instructions in respect of these cases, that although it is there is no doubt the local authority has had regard to the matters to which section 149 refers, all too frequently the evidence that it has done so is lacking. So there is no proper record to put before the court evidencing that process. Before we take a more detailed look at that, if you read just one more judgment of this subject, then do read the case of Bracking, especially the judgment of Lord Justice McComb at paragraphs 59 to 61, largely repeating the advice and the guidance given in Brown, but nonetheless worth a read in its own right. Well, we turn now to the salutary PSED lessons slides. And these are lessons that Andy and I have taken from recent case law and perhaps containing key tips as to how to avoid challenges in the future. So as the first point on the slide indicates, we often learn the most valuable lessons from the experience and probably misfortune of others in the context of litigation. And that is certainly the case in respect of Nur and Birmingham, a recent case in which Birmingham had the misfortune of coming a cropper at the hands of David Locke, QC, sitting as a Deputy High Court judge. That was, of course, a judicial review challenging the application of the local authority's housing allocation scheme in respect of a family from recollection with adult children, who therefore did not qualify for the preference given to locally to families with minors, with children. And unfortunately, in that case, Birmingham, although it had complied or indicated in evidence that it had complied with the PSED, was simply unable to put before the court the records to evidence that fact. And so a key lesson we learn from Nur, and indeed from other cases, those listed on the bottom, not least, bottom of the slide, not least, it is absolutely critical to be able to show to the courts and to evidence the process that you have followed in complying with the public sector equality duty. And so in Nur, the evidence simply did not disclose the equalities analysis prepared by the council in advance of the adoption of the allocation scheme. And any proper examination of compliance by a public body with the PSED duty must demonstrate how the potentially discriminatory effects of policy decisions have been considered by effective decision makers at a public authority, public body. So obviously do comply with the PSED first and foremost, but just as importantly, in preparation for any possible questions, queries, or challenges about your policy, make sure that you evidence the process that you have followed and set it down in a formal document. And indeed, if there are substantial changes to your allocation scheme, make sure you consider the potential impact of those changes on various protected groups, such as the disabled, such as, for example, the example Andy gave, traveller families. And if necessary, put that put that decision before Cabinet with proper information, proper stats, so that you can demonstrate that the obligation has been properly complied with. Well, we turn from evidencing the process to road testing it. And in order to comply with the PSED, it is absolutely critical that, as indicated in respect to the last slide, you consider the possible impact, the potential impact of the policy, and not just the policy, but its individual provisions on particular classes of individual, especially those, of course, with protected characteristics. And so it's critical to road test the policy to evaluate and consider potentially discriminatory effects. And this again is a lesson that we take from Birmingham and Noor, in which, as you'll see from the italicized text halfway down the slide, the PSED requires the Council to have recognised the potentially discriminatory effect of its policy and to have specifically reached the decision that one group of residents should be preferred over another. The PSED requires that conscious focus on the equality impacts, requires that conscious focus on the equality impacts of a policy. There are, however, important limitations on the requirements of Section 149, and indeed on the classes of person that you are, in an anticipatory sense, required to take into consideration. And although we are somewhat pressed for time, I'm going to read out two paragraphs from the Gulu and Ward and Hillingdon cases in which Andy and Kelvin were involved about the limits of the PSED, and it's from the judgment of Lord Justice Lewison. They're quite lengthy paragraphs, so bear with me, but I think they are nonetheless worth reciting. So at 72 and 81, Lord Justice Lewison provides as follows. So Mr. Rutledge submitted that in formulating the policy, it is not incumbent on the policymaker to assess the potential indirect discriminatory effect on every conceivable group that shares a protected characteristic. I consider that there is considerable force in that submission. It could not credibly be suggested, for example, that in formulating its housing allocation policy, Hillingdon ought to have considered its potential impact on Native Americans or Australian Aborigines without some specific cause to do so. It may well be the case that in formulating a policymaker has conscientiously attempted to assess the potential indirect discriminatory effect on groups sharing protected characteristics, but has reasonably and in all good faith overlooked a particular such group. It would need to be shown that the policymaker had given adequate thought conducting such inquiries as might be necessary to decide which particular protected groups ought to be considered. But if, having done so, a particular protected group was overlooked, I do not consider that without more that would amount to a breach of the PSED. So pausing there for a moment, in essence, he's saying that you have to conscientiously assess the likely impact of individual provisions of an allocation policy. But provided you have conscientiously done so and you have tried to anticipate the likely effect on particular groups of people, of applicants, then you won't necessarily be criticized for having overlooked a particular group if there was no trigger compelling you to do so. But he goes on at paragraph 81 to say this: that is not a complete answer. In my judgment, it is incumbent on the policymaker, once confronted with the omission, to justify the discrimination as regards that particular group. If a policy amounts to indirect discrimination against Group E, I do not consider that it is an answer for the policymaker to say that it has considered groups A, B, C, and D. And that really brings us on to the next slide, which is the obligation to formally review the effect of a policy at regular intervals. And indeed, as we saw on the first of these salutary lesson slides, to evidence that review. Because in essence, what Lord Justice Lewison was saying is look, you may have complied with the obligation at the outset, and you may have conscientiously addressed your mind to the categories of person who might be affected by a particular policy. But once you are alive to the fact that there is a class of person that you have not considered, it is not enough for you to then say that you have considered all of the others. You have to go on to consider the effect on that group and consider whether your policy nonetheless is discriminatory or non-discriminatory, and whether any potentially unfavorable treatment can be justified. And this is where Hillingdon fell down in the Gulu and Ward litigation, because although they had complied with the PSED at the outset, when they learned of its likely impact on traveller families, they had not then reviewed the obligation under Section 149 and their compliance with it. And so that was their shortfall in Gulu and Ward. I've indicated at the bottom of this slide that, of course, consultations are required about major changes of policy under Part 6 of the 96 Act. And when those changes are made and when consultation takes place, of course, local authorities, under their obligation to keep compliance with the PSED under review, will be required to assess the effect of the PSED on, assess the effect of the change they're proposing to make on particular classes of person in order to continue to comply with the PSED. And then last but not least, beware the light touch. As we indicated at the outset, the PSED requires a rigorous consideration of its various elements. And so, for example, in Brown that we've already looked at, it was provided and held that an incomplete or erroneous appreciation of the duties will mean that due regard has not been given to them. And then, of course, in Hurley and Moore, provided that the court is satisfied that there has been a rigorous consideration of the duty, so that there is a proper appreciation of the potential impact of the decision on the equality objectives and the desirability of promoting them, then it is for the decision maker to decide how much weight should be given to the various factors informing the decision. And so, as you will see from this particular quotation, the PSED is about process. It is about stopping and thinking. Have I had due regard to the need to eliminate discrimination? Does this policy meet that objective? But provided you have due regard to those matters, and provided you do so in a rigorous and conscientious manner, then the PSED does not require any particular outcome. And the weight to be attached to the particular factors will generally be left, unless it is Wednesbury unreasonable, to the local housing authority. So bearing in mind that we are almost at 5 to 12, and I've probably got a maximum of 10 minutes left, he says optimistically, let's turn from the PSED to the subject of incorrect allocations and false information. So the short point that needs to be made here is that, as we saw under Part 6, allocations must be made in accordance with the scheme that is adopted by the local housing authority. But importantly, an allocation that is made not consistently and not in accordance with that policy will not result necessarily in the tenancy that results from it being void. This was a matter which came before the courts in 2010 in the case of Birmingham and Kazim. And in that particular case, from recollection, Birmingham had let's call him a rogue officer who had been making allocations under Part 6, which were plainly not in accordance with and consistent with Birmingham's allocation policy. And in that particular case, there was no evidence from recollection that the persons to whom the allocations had been made had been complicit in that process or offered any inducement. And so this was really a question of an incorrect allocation on the part of the officer, simply not consistently with the allocation policy. And the argument put before the court in that case was that as a result of that process being incorrect, then the tenancy that resulted from it, the grant of a tenancy that resulted from it, must necessarily have been void. Well, that was an argument which was rejected by the courts in a judgment given by Lord Newburger, then Master of the Rolls. And the holding in that case is that incorrect allocations will not necessarily be void as a result of an incorrect allocation, and will remain effective generally unless set aside by a court in judicial review proceedings. And you'll find that holding at paragraph 28 of the judgment. So the fact that the anterior public law procedural requirement of compliance with the scheme was not complied with by no means necessarily means that the subsequent grant of a tenancy was invalid. And one very simple example that was given emphasizing the conceptual and legal difference between allocation on the one hand and the grant of a tenancy on another, is that, of course, an allocation may not ultimately result in a grant of a tenancy. So it may be that, for example, somebody is selected for an offer of accommodation under Part 6, and indeed that they are made that offer, but they reject it, and therefore there is no grant. And so for that, and indeed other reasons, numerous other reasons given by the court in Kazim, it was held that an error in the process under Part 6 will not necessarily, and will probably rarely, result in a tenancy granted under Part 2 of the 1985 Housing Act being void. And the same conclusion follows. So it was held in Kazim, even if the inconsistency in the allocation process is the result of a misrepresentation made by the applicant, him or herself. And so in the same way that an error made or an inconsistency made by the allocations officer will not result in a tenancy being void, the same follows if in fact, during the course of the allocation process, it is the applicant who has misrepresented his or her position. But in that case, as no doubt many of you will be thinking, it may well be that Ground 5 in Schedule 2 to the Housing Act 85 provides the local authority with a ground for possession of the property. And so in the case of Oshin and Greenwich, this matter fell for consideration. And it was a case in which there had been misrepresentations in the course of the allocation process, and the court accepted that in this particular case, the misrepresentations made in that anterior public law process of allocation and selection had a bearing on the subsequent grant of a tenancy, which was made separately under Part 2 of the Housing Act 1985. And in those circumstances, therefore, Ground 5 was available to the local housing authority. And you can find similar dicta to that effect in the case of Kazim itself at paragraph 32. And then lastly, on the subject of incorrect allocations and false information, to remind you that, of course, there is very much, as under Part 7 of the Housing Act 96, a criminal offence under Part 6 in the event that an applicant makes a misrepresentation in the course of the allocation process. And so those who misrepresent their position in the way that is provided for by Section 171 can be subject to criminal prosecution. Well, let's take a brief look at remedies. The remedies available in respect of allocation decisions are relatively few. And so we have under Section 166A, the possibility of an internal review. And indeed, an allocation scheme must make provision securing the right to request a review of two types of decision. First of all, a decision about the facts that are taken into account by a local authority in the process of making allocation decisions. And then secondly, any decision that the applicant is ineligible to be part of the scheme or is not a qualifying person. So those are the two circumstances in which it is possible to request an internal review. Very briefly, it's also conceivable and indeed possible that an applicant will, in the event of maladministration, take a complaint to the local government and social care ombudsman. As you'll see from the slide, that is exactly what happened in the case of the London Borough of Bexley. A complaint succeeding before the ombudsman resulted in a remedy, including the offering of a further review. Generally speaking, though, the principal remedy in respect of allocation decisions, as we've seen from many of the slides in this presentation, will be by way of judicial review. And if you put in a search of allocation decisions into Westlaw, you'll find that the majority of those cases concern London authorities, perhaps not surprisingly, given that demand in London outstrips demand for housing elsewhere. But it is London authorities who appear to bear the brunt, if you like, of challenges before the administrative court. It is not uncommon, as Andy mentioned, in the context of those judicial review challenges, for there to be challenges about infringements of European Convention of Human Rights rights. So Article 8 and 14 are often relied upon by claimants in tandem, as Andy said, with discrimination points under the Equality Act in support of their claim for a declaration, for example, that the allocation scheme is unlawful. Now, that gives rise to the rather vexed question of damages claims for potential Article 8 infringements. As Andy mentioned, the likelihood is that were this matter to be decided, it would be found that allocation schemes fall within Article 8, and therefore that there can be an infringement of Article 8 rights in the context of allocation decisions. If that is the case, then of course there is the potential for a damages claim for any such infringement. There is of course a caveat in Section 8.3 of the Human Rights Act 98, which is that no award of damages is to be made unless the award is necessary to afford just satisfaction to the claimant. And an example of a claim in which such an argument was put forward is McDonough and Enfield London Borough Council. That was not in respect of Part 6, and so the whole Article 8 issue did not fall for consideration, but was in the context of homelessness. In that particular case, the claim failed because the court found that there had in fact been no infringement of Article 8. But conceivably, that prospect remains, and it's an argument that may be run in due course by claimants, solicitors, and barristers. And then my last slide before we turn to questions and answers concerns, as opposed to public law remedies, private law remedies. And as has been the case, and we've known for many years, the exercise of functions under Part 7, that is homelessness functions, does not give right in the event of infringement to a private law right and a private law cause of action in damages in, for example, tort. And the same position applies in respect of Part 6. And so there is no common law duty of care that is owed in performing the statutory duty to allocate. This was considered in the case of Derby, in which it was held by His Honour Judge McKenna, in that case sitting as a High Court judge, that the principal difficulty facing the claimant in this case is exactly the same difficulty as was identified in X and Hounslow, namely that the claimant's essential complaint is that the council was not exercising its statutory duties and powers properly, which the cases show is not sufficient to give rise to a duty of care. So no common law duty of care in respect of the exercise of functions under Part 6, in the same way as there is no such duty in respect of the exercise of functions under Part 7. And so in private law, it would seem local authorities are safe from suits as to damages. That, I appreciate, has been a fairly whirlwind tour through some recent case law on remedies and indeed on the public sector equality duty. We're now almost at 12:05, and therefore I'm going to hand over to Andy to take the lead on the question and answer session. Thank you for listening.
Thank you very much, Dean. I think those who control us, Andy knows who he is, have done this webinar so that you can ask Q&As at the bottom of the screen. And indeed, I've answered the best I can, I think 14 of them so far. Obviously necessarily fairly brief. All I would say at this stage is that there was a pre-question. I'm not going to embarrass the questioner, it's a very good question, as to saying who it was, but it's David. And he asked a very good question about the problems of eligibility and Brexit, particularly in light of a recent decision regarding universal credit, and whether in fact that may impact upon Part 6 applications and whether that people are eligible. All I would say about that is I suspect not, because the Part 6 guidance, and that's one of the reasons, as I indicated, that it had changed in December of last year, makes it quite clear that it has considered people who have previously been entitled to remain under European law. And you can see that, for example, under, I think it's 3.11 of the guidance. So never say never, and I haven't had the opportunity of going into it in any detail, but it doesn't seem as if the situation with regard to eligibility as opposed to qualification is any different than you can see in the guidance at paragraphs, well, it's actually paragraphs 3.8 onwards, but in particular 3.11. But obviously, if you want to come back on that, by all means, email one of us and we will read it properly.
Andy, I see there's a question from Natalie about triggering the consultation duty.
Yeah.
And I don't know whether you've had a chance to look at that, but
I have. I think I answered that one.
Oh, did you?
I think there's been questions on that and the right to review. And so just to take both of them very quickly, consultations, you only need to consult on major policy decisions. So for example, everyone consulted, of course, when the Localism Act came into force in 2012 and people changed their schemes to kick off people who weren't actually in housing need. And clearly, if you were to introduce for the first time, for example, a residence requirement, it seems to me that that's the kind of thing where you might need to do a consultation. If, however, one is tinkering, and that's my words, not the official words, with any of the policy, so for example, perhaps giving further exceptions to the residence qualification, I don't think that would require consultation at all. And I think one can overdo the consultation provisions in that respect. So it rather depends on the impact and the nature of the amendment being done. As to reviews, because I was asked a question of, is there a right to review? And I think Natalie has also asked, and what about after that, after you've had the review? Well, of course, there is a right to review of decisions made under the allocation policy. One can see that in section 166A9. It's a bit sad that I know that, but one can see that. It's not as regulated as it is for the purposes of Part 7 and homelessness, where, of course, one has the whole section 202 and 203 and the regulations, etc. So there needs to be a right of review. If one's not happy with that review, well, of course, like any public authority, public decision, it's judicial review. I mean, in theory, as Dean indicated under remedies, I suppose you could go to the Ombudsman, but it's likely more to be a judicial review on the basis of some procedural irregularity or some classic public law complaint as to fairness or whatever.
Yeah. Andy, can I just come back on the consultation point? It's obviously not had a lot of time to consider it, but you may find some assistance in the case of Crown on the application of Smith, Natalie, and East Kent Hospital NHS Trust. That's a case that I've looked at frequently in the context of licensing, and discusses the circumstances in which a local authority is required to reconsult about a proposal that it is intending to introduce. And it deals with what constitutes essentially a modification of the scheme or a major change that is so fundamental that it requires consultation. So there may be some helpful guidance in that case. It's Crown on the application of Smith and East Kent Hospital NHS Trust.
I know there's a question from Fabian. Fabian, I hope you don't mind. I think that's a wider question, allocation schemes. I appreciate its transfers of accommodation are within the allocation scheme, and you can have a look at section 159 as to where they are. And incidentally, I answered one question which talked about transfers from sole to a joint tenancy, and maybe even vice versa. Well, that wouldn't be caught by the allocation scheme because you're not transferring accommodation. But if you have mutual exchanges and so on, they would tend to be part of. So you have transfers to other accommodation, that would be part of the scheme and under, I think it's subparagraph 4B of section 159. But as I say, Fabian, you're welcome to drop me an email on it generally, but I think for the purposes of allocations, I think we ought to stick to the Part 6 decisions in particular. We have had a question about would the local authority likely be criticised for accepting a refusal under a letting policy, a private registered provider's letting policy, and that qualifies under the allocation scheme. I mean, by Friday of this week, and I don't know if he's on the line, I am meant to be completing an advice as to cooperation between a housing association and a local authority. These requirements aren't a requirement that you have to accept somebody, but what you normally have a clear arrangement, and therefore your ability as a private registered provider of social housing to say no is strictly regulated. And of course, therefore, you need to, when you have your own policy, which, as I say, is not a statutory policy for a PRP, one has to bear in mind what the policy of the local authority in your area is, because obviously otherwise it may become ridiculous and it may actually be that in fact you're not helping at all. But yes, of course, you're entitled to have your policy, and of course you would hope that that would marry up with the local authorities, and indeed there'd be a dispute mechanism within that if you weren't happy with the would-be nomination from the local authority. What about, Dean, the question from Rebecca, which is, does the review have to take into account new information, or can it be based on the information the original decision was made on?
Oh, thanks. Yeah, I'm just catching up on the questions. Yeah, as far as I can see, it would be entirely right to take into consideration all relevant facts at the time of the review, in the same way that takes place in the context of homelessness. So any new material change of circumstance should be taken into account to make sure that the decision made by the authority at the point of review is lawful in the public law sense and takes all matters into consideration.
I have to say, from experience, I've never met a challenge to a review decision per se. What tends to happen is people skip over that, and that when you see the grounds being pleaded by claimants, there may have been an internal review, but that's not really what's being challenged. It's the more substantive question as to the Section 19 issue, as to the provision anyway, rather than how you dealt with it, because it may be accepted that you've made the right decision on the basis of the allocation scheme as it is set out.
Yeah.
I would just say, Dean, because I read this somewhere in one of the cases I was going through, there is an interesting position with regard to exceptionality cases, and of course the discretion given to local authorities. It's a bit akin to direct offers in one sense, and it's this: one's got to be a bit careful with exceptionality, because an allocation scheme's got to be clear. You've got to be able to follow it, and you've got to know, if I'm an applicant, I've got to know how it operates. And if a large number of properties are going out because the officer says this is exceptional, therefore we're going to allocate you a property, I'm entitled to say that's not fair. Having said that, there is some merit in saying that sometimes situations are out of the norm, or maybe haven't been considered as yet. And rather than stick to a strictly regulated system which can't possibly cater for all situations, there may be at times need to be a senior officer assessment at the right time. It would very much be the exception rather than the norm. And all I would say is not that you have to have one, or that it shouldn't be in there, but if it is in there, make it clear that it's the exception rather than the norm. And it, in particular, for example, is there to make sure that not only are people treated fairly, but they are not discriminated against. And therefore, at the annual review, you should be able to say, well, nobody was housed under that provision, or one or two, but very limited. It's got to be exceptional in the real sense of the word.
Yeah, that actually gives rise to a point that, of course, was one of the central points in the H and Ealing litigation, which is that in order to ensure that your policy is sufficiently flexible to cater for the needs of those with protected characteristics, it really is important to include what was referred to in that litigation as safety valves, so that if there are circumstances in which your policy would, on the face of it, discriminate against certain persons, you have the ability in exceptional circumstances, if you like, to disapply the policy and to allocate according to a wider discretion. Okay,
I think that is it. As always, on the question and answers, clearly we're ready and able to take instructions and so on the right matters. And obviously, if people have questions arising from this, as with all webinars, then please feel free to drop us a line if they're fairly straightforward, and it's not going to take hours to answer. But it's been a delight as always, and I hope you've enjoyed it, and I hope you found it useful. We would, in particular, be interested as a team to know what areas you would like us to cover. As Dean mentioned, we have our annual webinar program coming out soon. I hope this week, maybe next week, but certainly in the next few days. But of course, that doesn't mean we can't do webinars outside of that, such as this one, where we thought it was particularly important that people had a look at their allocation schemes and made it clear what they needed to do, if anything, in relation to them. So please feel free to do that. Just lastly, there's just one final question from anonymous attendee. I know, I don't think there is actually, no, sorry. No, that's me, sorry. That's me.
You asking yourself questions again?
Yeah, this could take some time, everyone. So certainly from me and Dean, very much appreciate the fact that you've joined us, and hope you'll join us for some of our future webinars. And as I say, please feel free to get in touch.
Yep. Stay well, everyone. See you soon.
All the best.